All right, so here's a quick real estate education moment. Did you know that individuals with disabilities can request something known as a reasonable accommodation in housing? And most times, landlords, HOAs, so homeowners associations, and housing providers have to allow it. This is most times, not all the time. Well, I'm going to talk about that today. But before I do that, let me introduce myself. My name is Kim McBride, also known as Get Keys with Kim. I'm a licensed associate broker as well as a broker in real estate in Maryland, DC, Virginia, Pennsylvania, and the Dominican Republic. Let's talk about it, y'all. Let me first start by explaining what a reasonable accommodation is. So that is a change to a rule, a service, or a policy that allows individuals with disabilities to have equal access in the housing arena. It is in no way giving special treatment, but rather equal treatment. So here are a few examples. Some are common, some you may already know, and some you may not. One we've already discussed, which is the service animal or the emotional support animal or support animal versus pet. And so that would be an example of an unreasonable accommodation. If you don't know what I'm talking about, go back a few videos because we did discuss this already. Another example would be reserved parking spaces. We've seen that whether that's been at an apartment building, whether that has been in a community, whether that has been at the mall. We've all seen the reserved parking spaces, which would be considered a reasonable accommodation. Another one that is probably not as well known would be rent payment flexibility. So allowing someone that receives some type of consistent income, but that is not from working, such as Social Security or disability, to pay their rent in a flexible manner that would allow for them to accommodate when they actually receive those funds so that they're not always receiving late fees or being sent to court due to failure to pay rent. There may also be the ability to have a living caregiver live in the unit and not be counted as an occupant. So there may be restrictions on how many people can live in a particular space, but a caregiver would be allowed to live there and not be considered an occupant and not have to go through the rental and the background checks just like everyone else. Now this is case by case, but you get my drift. We also need to add to the list allowing communication to be in different forms. So we're talking about large print or email or in formats that may make it easier for individuals that have visual impairments. During things like meetings, this is also allowing a support person to be there in the room with the individual. And then another would be the ability to transfer to another unit should a person with a disability need something like a ground floor versus a higher level floor. I just want you to remember that reasonable accommodations changes policies and rules, but reasonable modifications actually change a structure. So this would be like installing grab bars or ramps and things like that. Unless there is an undue financial burden or even an undue administrative burden, housing providers under the fair housing laws must consider reasonable accommodations for individuals with disabilities. And that's because everybody deserves to have equal access to enjoy the space in which they live, regardless of whether they are able-bodied or they have some type of disability, whether it's seen to the naked eye or not. So I've done my part today. I just need you to do yours. So be sure to like, share, comment, ask your questions, follow me, come back, make it a great day on purpose, and then do what? Get keys with Kim. All right, I'll talk to you later. Deuces.